What's up, everybody? Welcome back into another episode of The Lawyer You Know. We get our first look at Donna Adelson's new legal team, all the work they still have to do before we can get this thing going to trial, and the work they have to redo because of the conflicts from prior counsel. And they say those conflicts are even worse than we know at this point, or worse than even the court knows at this point. What do they mean? Let's take a listen to this hearing together. By the way, if you guys are still following this case and still have questions, let me know by hitting that like button and in the comments section, whatever your questions are. I have read the reports. I have seen the allegations that she has been getting some very negative treatment in jail, and they want her to be out on bond pending this trial, that she's not dangerous. She was out during Charlie Adelson's trial. It's going to be very difficult with the fact that they arrested her at the airport with a one-way ticket to a non-extradition country. That's going to be a little problem in their argument, but nobody should be abused in jail, especially when they're there presumed innocent, waiting for trial. So we'll still see what happens there. They talk about scheduling that and among other things in this hearing. Let's take a listen together.
Jackie Fulford on behalf of Ms. Adelson.
There are a couple of things that we wanted to address initially. The state had previously perpetuated the deposition testimony of Dr. Clark, the former medical examiner. That was done by prior defense counsel. We've reviewed the material. There was one portion at the end that we had requested that they edit out, but we would stipulate that would be appropriate to present to the jury during the trial in our case. We've spoken with Ms. Adelson about that as well. And even though we were not counsel at that, defense counsel didn't ask any questions, and that would have been our strategy as well.
So one of these depositions, they don't have to redo. They're going to adopt what was done before. They said defense counsel didn't ask any questions, so that their questions can't be held against them necessarily if they were conflicted or doing it with, some other purpose in mind. But they said they didn't ask any questions. We wouldn't have asked any questions either. That would have been our strategy. So no harm, no foul. We will accept that.
Very well. You may continue.
We are also stipulating to the foundation of the extraction of Wendy Adelson's cell phone that was conducted by Marsha Rodriguez, who will be out of the country at the time of the trial, so that they don't need to present her testimony in order to introduce the contents through other witnesses. We did want to inquire with Your Honor about the status of the in-camera examination of prior investigator.
With that,
in-camera discussion with the prior investigator, which probably means there may be some conflict issues. There are some issues that maybe they can't use the private investigator. Maybe they're going to have to redo some things the private investigator did, because was he conflicted in his representation or work that he may or may not have done on Charlie Adelson's case? I haven't heard a lot about this. I don't know if it is a similar investigator or what, but usually that's what the in-camera discussion would be about.
Lynn, has a date already been set for the?
I don't think so. Did we set? We didn't set a date yet.
I provided his cell phone number.
This would just be me meeting with him. It's not a motion.
Yeah, no.
Okay.
I'll follow up on that.
We do have some issues with regard to discovery and prior case management. Your Honor had indicated that based on the conflict that existed in prior counsel, you would understand if we were going to redepose some of the witnesses that had previously been deposed by prior counsel. There are three such.
Hold on. I believe I said if you needed to raise the issue, you certainly could, but
We'd like to
do
raise
not
the issue.
accept that as a blank permission to redepose.
We didn't, Judge. We
Okay.
didn't.
So there's a difference, right, between the judge allowing you to redepose some witnesses versus you can ask to redepose some of the witnesses. And if we find good cause necessary, then you can redepose those witnesses. But it's not just a blanket allowance that they're going to be able to redepose all these witnesses. However, if they can prove that that conflict or what the lawyers did not have Donna Adelson's best interest in mind, or because of the timing, even if a co-defendant deposed them, that's not going to be good enough for them in this case. That's a lot of work to redo on a case like this, which is why we talked about if Rashbaum wasn't conflicted off, or if it was a waivable conflict, it just makes so much sense since he's already done so much of the work, and he knows the case. For any new lawyer to jump on was going to be difficult.
Go ahead.
So we've been working to schedule depositions with the state, and for this morning, for the first time, we learned that they do object to us redeposing 3 of the state's witnesses. One would be Chris Corbett, the second would be Special Agent Patrick Sanford, and the third, Robert Adelson. Mr. Adelson is the son of Mrs. Adelson, of course. His deposition when
The black sheep of the family, the son that is not in cahoots with the parents, I believe, is who Robert Adelson is.
not be lengthy, but we do need to redepose him. The depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands. And
So we're going to back that up just to make sure you hear that again. The depth of the conflict from Mr. Rashbaum, from representing Charlie Adelson and Donna Adelson, is much deeper than the court understands. The same court that's been the judge on all these cases, the same court that had the in-camera discussion with prior counsel, the court that knows basically everything about this case. She's like, no, you don't know everything. You don't know how deep and bad this conflict is. And because of that, we have to redo all of this. We have to ask questions. Rashbaum refused. I'm ad-libbing here, okay? But what I'm reading between the lines is we have to ask questions Rashbaum refused to ask. We have to take the avenue of, did Charlie do all this behind his mom's back? Was Charlie an orchestrator of this? We've got to ask, were you connected to Charlie or were you connected to Donna? Could be very different defenses than was going to happen with Rashbaum. And that's very deep and very important, Judge.
the depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands. And to the extent you'd like to know further why we would like to depose these witnesses and that particular conflict, we'd like to be heard ex parte and in camera.
So that means we won't be able to watch ex parte outside the presence of the jury, outside the presence of the prosecutors, just the defense attorneys and the judge, to discuss how deep that conflict is, why it is such a problem now, why they are going to have to redo so much work on this case. This is not a good look for Dan Rashbaum, right? Now, we don't know exactly what they're talking about. We're probably not going to know. It's probably going to have to reveal some attorney-client privilege information. But we will know if the defense theory starts becoming point the finger at Charlie or other people or Charlie's friends or whatever it may be, that clearly that's a major problem for Dan Rashbaum trying to handle this case.
With Ms. Adelson present to provide some information to the court as well on some attorney-client privilege.
And they want Donna there so Donna can corroborate and say, yeah, Rashbaum told me we can't do this, we can't do that. Again, I'm making that stuff up. I don't know what the details are, but why would you want Donna Adelson there except for to say, this is what he instructed me. These are the conversations we had. We were trying to protect Charlie more than we were trying to protect me. I don't know. Something to that effect, though, could be a major issue in this case and create the necessity that the judge has to allow these lawyers to go redo a lot of the work Dan Rashbaum has already done.
Information.
And frankly, sometimes you can use what a co-defendant did or that depo, but if Rashbaum was more focused on protecting Charlie than Donna, maybe you don't want to use those depos. Maybe you have to go redo those as well.
All right, this is going to need to be memorialized to the extent that you can in a motion. As far as any hearing that would occur in camera, I will make a decision on that. But first, I actually need to read the basis of what you're seeking and why.
Thank you, Judge.
With respect to Ms. Corbett, Your Honor, we haven't even received Sergeant Corbett's completed revised presentation. That is what the defense intends to take his deposition concerning. We've been told that we will have that presentation by this discovery cutoff, and so we were actually going to have to file a motion to extend the discovery cutoff for purposes of taking his deposition. And that was tentatively scheduled for May 14th. Being that that would give us approximately 2 weeks to review the revised presentation. That's the reason for Mr. Corbett's. That's not a conflict issue, but we can certainly memorialize that in a written motion if that's what Your Honor would prefer.
Just going back and looking at the dates and the different cutoffs. Sure.
We're going to bump up the speed a little bit. They're going to start talking about scheduling and dates and things like that.
30 is the discovery cutoff by order right now.
So April 30th is when discovery is supposed to cut off. So that would be great. Get us moving, get us going towards trial.
Ms. Dugan, as to providing Sergeant Corbett's presentation, Why is this going to be so lengthy?
He's just working on the cases that are in front of him right now, but he has assured me that he's going to be working on this presentation as soon as he possibly can. I don't know of any new information in the presentation than what's already been given to him. It's more of formatting and making it look better as opposed to anything substantive. And my memory, if it serves me correctly, is that prior defense counsel's deposition of him was done after the same, as far as them getting the copy of what we were going to use, as far as everything substantive we were possibly going to use is in there. But, you know, the final result might look better at trial and be formatted in a different way. But substantively, it was all there. We certainly, and we want to be reasonable. We do object to, as far as all of these witnesses, they sent us about 24 hours they need to depose several witnesses.
And that's a lot, but that's not crazy unreasonable for a case this in depth with this many witnesses and this much going on, this many co-defendants. 24 total hours of depositions to me is not crazy. That doesn't sound crazy at all. But again, a lot of that is redoing work that prior counsel has already done, which is the really unfortunate part.
Worked with them to get times that we are available, and we'll continue to do that. Some of the witnesses have never been deposed before. We obviously have no objection to that. Some of the witnesses have been deposed by prior counsel of other co-defendants. Looking at the rule 3.220, it says any cases, including ones with multiple co-defendants or even consolidated cases, no one should be deposed more than one time unless good cause is shown.
The defense has a good response to that, and they're right here in Florida, and the judge knows it too. But she's trying to not have to do more work than they have to, and I get it, and it makes sense. But the way that they charged and handled this case, handling them all different times, different years, all different, very different trials and separate trials, that's going to affect the way that rule is read.
If it's something that pertains to their client that's new, we don't have any objection to that. But as far as just setting these people for hours and asking them a lot of the same information that's already been said in prior depots, we would object to ask and answered and not want those people to have to be deposed again. And then as far as the folks that they named, I think it was Agent Stanford and Corbett and Rob Adelson, that Donna Adelson's former counsel has deposed. As the court said, we would ask that good cause be shown. We're fine with that being ex parte and in camera, but we would ask to have that done, be able to weigh in on that from our side as well in those same situations, and object to them being deposed again.
So the state is not being unreasonable. They said, Judge, it's fine if it's been redone. We just ask that good cause be shown, which is exactly what it should be. I don't think they're going to object if the judge, especially obviously, but even if defense counsel's like, listen, this conflict is bad. It's worse than you thought. We need to depose these people. I don't think the state's going to give a lot of pushback. Honestly, they don't seem to be handling this case that way. They haven't throughout the years.
There is some new information in Corbett's presentation as of April 30th that they didn't know about before. We would absolutely be fine with him being deposed on that information, but just not having to go back through what's already been said with hours and hours of depots and prior testimony.
All right. What I am not fine with is moving this trial date if it does not need to take place. April 30th is the discovery cutoff. We're going to leave that in place for now. Everyone is to work accordingly up to the deadline. If it has to be extended, it will. But there's still 2.5 months to that point, right?
Yes, sir.
We'll drop the motion, Judge.
Yes, sir. And, certainly.
Trial's supposed to be the beginning of June. So we need that discovery deadline to stay at April 30th because stuff always happens after the discovery deadline. And we have basically the entire month of May after that before the trial is actually supposed to start. And he really doesn't want to move the trial. This is moving pretty quick for a new set of lawyers.
By way of a brief response, and I will be brief, the rule cited by the state contemplates that the co-defendants are all being tried at the same time or have all been arrested. It defies logic to believe that.
These trials have been spaced out. They are not co-defendants that are linked by one information.
Thank you very much, Your Honor.
He's like, I agree with you. I know what you're saying.
Lastly, this morning, I provided a proposed order to the court from the August 30th and September 5th motions in limine. I prepared those based on the transcripts that I have prepared of those hearings. I provided them to the state twice over the last month and had not gotten a final answer. Does Your Honor want me to submit the transcripts from those hearings?
You can do so. I'll review them. Ms. Dugan has the proposed order. Is the state objecting to it, or you don't have an opportunity to review it?
I did speak with Ms. Kaplan about that and we reviewed it. We don't have any objection.
Very well. I'll still review the transcripts to ensure it is accurate, but trust but verify. Go ahead.
Yes, sir. There are some additional motions to suppress and a handful of motions to limine. I'm hoping to get the motions to suppress filed in the next week to 10 days, so that those can be heard properly. The motions in limine, we're certainly going to try and get those filed early to mid-April, so we can get those heard as well. I just wanted to let the court know that the motion to suppress that we filed last week is not the only one that's coming.
I believe the date that we were going to have for the pretrial motions, that was going to take place on Friday, May 16th. Obviously, more that can be heard prior to then will lessen the burden on that day, but anything that's still outstanding, that's the day it's going to be heard before we move into trial posture.
Yes, sir. Certainly with the scope and breadth of the motions that we are working on, and we'll try and get those on your calendar much sooner. And lastly, I wanted to update the court on the expert that has been retained. I spoke with them for the motion for change of venue. I spoke with them yesterday, Mr. Fulford and I did, and they are intending to provide us with the end product by the end of the first week of March. And as soon as we have that, we'll be providing that to the state and get that set, provide that to the court as well and get it set for here.
All right.
So they're trying to change the venue. That'll be interesting. That'll be interesting because we know the Adelsons don't like Tallahassee.
Concerning this report,
I don't think it's going to be moved, by the way.
and I'll leave this to your judgment, but do any of these matters need to be filed under seal or to alleviate essentially the issue you're complaining of for the motion?
Meaning, are you giving too much publicity to the fact that this case has too much publicity? Do we need to file any of this under seal? Do we need to do any of this without people watching?
Yes, Your Honor.
Very well.
Obviously, the judge is probably going to grant that. I disagree. I think it should be open, but I mean, it's Florida. It's crazy to think that this stuff is just, Florida is usually open, and for it not to be, something big would have to be in place.
Ms. Dugan, does the state have anything to raise today?
No, sir.
All right. Upcoming through the deadlines, as we've spoken about before, the discovery deadline will be April 30th. We'll also have one last case management on March 25th at 2:30. As needed from there, we'll have different hearings on motions and continue to move to June 3rd.
Thank you, Judge.
Thank you, Your Honor.
We are in recess.
And that's it. That is the end of the most recent Donna Adelson hearing, which was today. I think we're going to be dropping this today, the day I'm recording it. So let me know what question you have. Let me know by liking the video if you're still following this case and want us to as well. But that's all we got. Hope everybody has an awesome day. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.